Welcome everybody. My name's Stephanie Harris and Casey. I'm barrister at Garden Court Chambers who has been working on the issue of criminalisation of asylum seekers for too many years. If I tell you what it is, it's terrible, so I won't. So as you know, the topic of this seminar is the imprisonment of children and adults who seek safety and protection in the UK. The reason for having this seminar today is a follow-up report from a report that was produced in February 2024, aptly entitled No Justice Here. In that period of time, justice has not been delivered to many people who come here seeking protection, and instead of finding protection and safety, are subject to detention, imprisonment, prosecution, including amongst those people, children, as well as very vulnerable adults. So the launch of the new report, and there are copies of it around, there would have been one on your chair, but also we will be able to provide a link so you can get access to an electronic version, and there may be other ways in which we can make sure that this important report is distributed, so that people can get an insight into what is really a hidden consequence of the policies and the systemic undermining of the right to seek asylum that has followed the introduction of the Nationality Immigration Act in 2022 and the criminalisation of the very act of arriving and seeking asylum. So this report is called I Told Them the Truth, and then you'll hear from different angles what that means when your voice is not heard in a process that is designed not to facilitate human rights respect and protection, but instead to act as a means of deterrence and punishment for seeking asylum. When I came to think about what to say, just by way of an opening remark before I introduce our speakers and what we're going to discuss today, I was reminded of a case that I did with other colleagues in Chambers, Francis Webber and Raza Hussain, in 1998, and it may be a case that you're all familiar with, but it's as long ago as that, nearly now 30 years, ex parte Adimi. And that was the first case in which the courts recognised that there had been then systemic failure to implement in any way, shape or form the protections in the Refugee Convention against penalising people for the very act of seeking asylum, despite it being a fundamental element of the Universal Declaration of Human Rights in Article 14. And what Lord Justice Simon Brown said then in 1998, the problems facing refugees in their quest for asylum need little emphasis. Prominent amongst them is the difficulty of gaining access to a friendly shore. Escapes from persecution have long been characterised by subterfuge and false papers. As was stated in a 1950 memorandum from the UN Secretary General, a refugee whose departure from his country of origin is usually a flight is rarely in a position to comply with the requirements for legal entry, possession of national passport and a visa in the country of refuge. We are told that we need to have human rights reflecting current situation, but as long ago as 1950, it was fully recognised that refugees do not arrive with legal documents and in an orthodox manner. And it is perhaps one of the most retrograde steps to which the new government has only furthered its implementation, that we now do have not just no defence, but actually steps that will make it criminal for the very act of seeking asylum. So that's the overall context in which we're going to hear from a number of different speakers who have been working on this topic, and we owe them a great debt of gratitude, both Victoria Taylor at the Oxford Borders of Criminologies, who's done first-hand research at Western Jetfoil and into the criminal process, along with Maddie Harris for Human Rights Network, who have tirelessly put in huge amounts of time and effort to expose the injustice that has been taking place in the context of this legislation, and to bring it to our attention through this report and through other work. We're going to also hear from a first-hand account, a lived experience from Salah, Eldin, Adam, who's going to be assisted by Mr. Yusuf, his interpreter, to give you an insight into the human reality of policies that disregard not only fundamental human rights, but also the human being who is seeking to rely upon them. And in that context, we're also fortunate to hear from Basma Kamel, who's a refugee legal support officer, who will also give you a practical insight into what happens in respect of the journey for people in the asylum system, as well as having insight from Michela Carini, a solicitor at Bat Murphy, who has been highly instrumental in bringing legal challenges, both by way of judicial review and consequently through the criminal justice process, seeking to overturn wrongful convictions, especially of children who've been prosecuted as adults when they ought not to have been. And in addition to our advertised speakers, we also have the benefit of Henry Blaxland KC, our leading criminal defence barrister, who has been working with us on the overturning of convictions. So you'll get a full spectrum of a view about the process, and I hope how it can be successfully challenged. And I hope one of the big messages that you get from today is about how cross-discipline working collectively with academics, NGOs and lawyers can challenge what appears to be a pretty impregnable policy of the government with such harsh consequences for individuals. And part of what Maddie will talk about at the very end is the new challenges that we face, because there is in the new bill before Parliament extensive new criminal powers and offences that mean that whatever lessons can be learned from the way in which we've sought to try to challenge what's gone on so far, they can be read over and utilised when it comes to new powers that are being given to the police and the prosecuting authorities to further restrict and limit the abilities of people to travel. Because one thing that we do know is that whoever these policies are aimed at, the smugglers, the traffickers, the gangsters, they're not the ones who are sitting in prisons in Britain. And whatever the description about the new offences and their purpose, we know that it will be those seeking asylum, those who are in fact victims of these of criminal actions, who will face the biggest penalty. So that's quite a lengthy introduction. The first person we're going to hear from is Victoria Taylor, who, as I said, works for the Oxford Borders Criminology Department, which does fantastic research on these topics. And Vicky is going to give you the legal context, as well as some of her insights from her practical work of the legal regime and the criminal offences that she's been looking at the consequences of. Vicky.
Hey. Works. Thanks, Steph, and thank you to the Garden Court team for providing us with the space to discuss this today, and thank you for being here to discuss this issue. So this research is a collaboration between myself, I'm a PhD candidate at the University of Oxford Centre for Criminology, Humans for Rights Network, Refugee Legal Support and Captain Support UK, and we're the kind of small group of organisations working directly to provide casework and doing research on this issue of people being prosecuted for how they arrive to the country, in particular to seek asylum. So I'm going to start off by giving some introductory context so they're all on the same page, and outline some main findings of this report in particular. So people started crossing the channel on small boats in greater numbers towards the end of 2018. And quite soon after this became more prevalent, the Home Office began referring some people for prosecution, criminal prosecution, mostly those they identified as steering the dinghies across the channel, but not every person that was steering the dinghies, so it was quite a small number of people. And they were originally prosecuted with an offence under Section 24 of the Immigration Act 1971, which is the offence of illegal entry, and also for facilitating a breach of immigration law, that breach being illegal entry. However, in 2021, there was a series of appeals in the Court of Appeal that ruled that these prosecutions of boat pilots were unlawful because everyone on these dinghies was seeking to claim asylum. So they were not seeking to enter unlawfully, but only to arrive to seek asylum. And at that point, the act of arrival was not a criminal offence. Predictably, what the Home Office did was introduce the new offence of illegal arrival in the Nationality and Borders Act in the months following these Court of Appeal cases. And the new offence of illegal arrival was introduced in June 2022. The new offence of illegal arrival also increased the maximum sentence compared to the previous offence of illegal entry to a maximum sentence of 4 years, which is over the 12-month threshold for someone being liable for automatic deportation proceedings and potential exclusion from refugee status. And also had implications for the more serious offence of facilitation because it then became an offence to facilitate illegal arrival as well as entry. The NABA also increased the maximum sentence for facilitation from 14 years previously to a maximum sentence of life imprisonment, so quite a significant increase. So we were concerned with documenting the implementation of this new offence from when it was introduced in June 2022, and collaboratively we started going to court most days across 2023, and we published these early findings from June 2022 to the end of 2023 in our first report, which is here, called No Such Thing as Justice Here. And that goes into some more detail. So if you're really interested in this report, also I would refer you to that previous one. And this report in brief showed that asylum seekers, victims of trafficking, torture, modern slavery, and children with ongoing age disputes were being prosecuted with this new offence of illegal arrival and sometimes also facilitation, despite the fact that the government was saying that it was only bringing the most egregious cases against people smugglers. So there's a gap. However, despite the fact that we published this report, the practice has continued, even with the change in government. And so we wanted to write a new report that updated the previous one on what had happened between the end of 2023 and May of this year. So this is what this report is. What's in it? So it draws on the casework of Human Rights Network, Refugee Legal Support, Captain Support UK, as well as court observations, analysis of data collected by Freedom of Information request, which you can find on my What Do They Know channel, and also includes the testimonies of 8 people with lived experience of being imprisoned in the UK for these offences, including the first interview with someone who was under 18 at the time when he was put in adult prison and subject to the adult criminal justice system. So I draw your attention to that. I'm not going to go into a huge amount of detail because I encourage you to read the report, but just by way of how we've structured it, the first section focuses on the process and experiences of adults who are being prosecuted, including who is being selected for prosecution. Given the breadth of the illegal arrival offence, not everyone is being prosecuted, and their experiences on the journey between the sea, the court, the prison, and then also their experiences upon release. And then the second half focuses on the experiences of age-disputed children charged with offences as adults, which addresses issues of age disputes in Dover, experiences of these children in the adult criminal justice system, changes to Home Office policies to age assessments, and the harms and risks to children involved, which are quite obvious. So just to highlight some of the few key takeaways that are kind of overarching. In terms of numbers, between June 2022, when illegal arrival offence was introduced in the NABA, and the end of 2024, 455 people have been convicted of illegal arrival having arrived on a small boat. Only a handful have been convicted of facilitation for steering. And these prosecutions have continued into 2025. So we know that every week some people are being imprisoned still. Given the breadth of the offence, illegal arrival, anyone arriving irregularly could be prosecuted, but that would mean putting 45,000 people in prisons in the court system every year. So we were interested in how the CPS was applying its discretion and who it was selecting. Generally, we observed that 2 groups of people are being selected for prosecution on the basis that they have a higher culpability. Number one, predictably, are those people who are identified as steering the dinghy. whether or not they steered it under duress, because they didn't have enough money to cross otherwise, or because they were in a kind of arrangement where they swapped places. All of these undermine the CPS argument that they're more culpable, right? The second group are those with a previous immigration history, and that can mean a wide range of scenarios, including that they were in the UK as a child, went back to where they were from and then came back, or simply having put their fingerprints into the British system in a visa application centre abroad, so having never been to the UK. But then if they came to the UK, that was sufficient to trigger a criminal prosecution. So very low bar in terms of the people that we were seeing. And we also show in this report in particular how people can be selected for other more political reasons, showing how the breadth of the offence effectively gives the state the tool to prosecute anyone it disagrees with. And I want to draw attention to the case of a Palestinian man who was selected despite neither being a pilot nor neither having an immigration history that's detailed in the report. But it's a clearly political prosecution. Overall, the vast majority, if not all, of these 450 people who've been convicted have ongoing asylum claims. So there are clear questions about the compatibility of the current approach of prosecution under Article 31 of the Refugee Convention, which is intended, as Steph said, to protect refugees from penalisation. We also emphasise in this report in particular how victims of trafficking are being regularly convicted without being referred to the national referral mechanism. And we point out how the act of steering under duress could potentially be understood as evidence of having been trafficked. However, we know of no instances in which the modern slavery defence is being used as a defence in court or as a challenge to CPS charging decisions. Maddie will talk about this in more detail, but at the time of the report being published, we had identified 29 children with ongoing age disputes who were being arrested as adults. I think that number is now 30, and at least 18 of those spent time in adult prison. Just so you understand the general process, so most people who are arrested from Manston short-term holding facility, which is in Kent. They are then taken to a police station and most plead guilty to illegal arrival in the magistrate's court. And this extraction of early guilty pleas is because criminal solicitors are concerned that a plea of not guilty could result in a sentence of over 12 months, which is the threshold for automatic deportation proceedings and potential exclusion from refugee status. But the extraction of early guilty pleas means that it's restricted the potential avenues for legal challenge, so we're really struggling to get those through the courts. Most people, after they pleaded guilty to illegal arrival, are sentenced to 8 or 9 months imprisonment, but that's generally higher for cases with a previous immigration history, unfortunately, which are commonly over the 12-month threshold. The highest sentence we've seen so far is the case of Ibrahim Abbar, who was sentenced to 9.5 years imprisonment last year. He was found guilty by jury of 4 counts of manslaughter after the boat that he was steering in December 2022 broke apart, and very sadly at least 4 people drowned during the crossing. And he was also convicted of facilitating the arrival of survivors, despite evidence in court that he was steering under duress and that he did everything he possibly could to save those on the boat when it became in trouble. So I wanted to highlight his case as a particularly egregious one, and he's still in prison to date. I also wanted to highlight 2 key ongoing questions that we have, because it's important to share where we don't know the answers, and there's still things we don't know the answers to. So 2 things. Firstly, the impact of a 12-month sentence on exclusion from refugee status. None of the people that we know of who got over 12-month sentence for immigration-related offences have yet had an outcome on their asylum claim. And we don't know whether a 12-month sentence will result in them being excluded from refugee status. So that's something that we're continuing to monitor. To note that the Nationality and Borders Act, at the same time as introducing the legal arrival offence, also lowered the threshold at which someone could be excluded from refugee status for a criminal offence. And then secondly, we also know that a similar number of people are being prosecuted for illegal arrival having arrived on another route, so by plane or by lorry or by car, but we don't know very much about that group of people, similarly around 500 people since June 2022. Our knowledge of their situation is more limited and they're spread out around the country, so it's much harder for us to monitor what's going on. Just to end, I wanted to emphasise that obviously there's no evidence that these prosecutions can or do or will deter people from making the crossing. However, in these reports, we have shown how they target people seeking safety themselves, they cause considerable harm, and arguably breach the UK's obligations under the Refugee Convention and smuggling protocol as well. Thanks.
Thank you very much, Vicky. What we would plan to do is to have questions at the end. I could just comment on one point that you made about trafficking, which is that I am aware of a successful case where a referral was made by a young person who gave an account of being compelled to drive the boat against his wishes. And it was referred by the Kent Social Services. And in fact, to my shock and surprise, the NRM actually accepted there was a conclusive grounds decision. I think Francesca will know about that case. So there is a precedent. It's not a precedent in the sense that you could use it, but there's no question. And we have had expert trafficking reports that do identify different kinds of scenarios for the crossing itself, for the journey from France to the UK, whether there's been expressed threats of harm or actually just the fact that people who are desperate to come to the UK and have no resources, the offer of a free journey if you drive the boat, especially if it was a child, could meet the criteria for a victim of trafficking. So I think that's an important area, and there is a legal challenge about the failure of the Home Office to do any proper effective screening for trafficking, because their position is it's smuggling, it's not trafficking, but that's not correct, and we need to focus on undermining that. So just that, just in terms of there is that, obviously it would be good to document that if we're able to do so.
Steph, can I just add this? I mean, in relation to Ibrahim Abar, I mean, this is a deeply shocking case. There was a hung jury the first time. I know Richard Thomas, who represented him, was really very, very upset by the verdict in that case. It's been explained briefly. It's a man who was prosecuted because he was the tillerman on the boat. It's the only reason. He'd been threatened by the traffickers, but if he didn't do that, then he would, you know, he would meet the fate that a lot of other people would meet. And he tried to save people, and yet a jury convicted him. It's a deeply shocking case, and the problem is it's difficult to see what if anything could be done by way of appeal at this stage.
Yeah.
Stephanie, can I just ask you to ask people to speak up though, because I'm a bit deaf, just
Sure.
a plea.
Okay, can you hear me?
I can hear you.
So it's maybe we're straight off. Okay, fine, we'll raise our voices. So that's a helpful thing to know, because we're going to be dependent now on Mr. Yusuf to translate for Salah, who I explained at the outset. Mr. Adam has had a direct experience of being subject to criminal prosecution, and he's going to give the perspective of his own from that experience. If there's any difficulty with translation, then obviously just tell us, but it's going to need loud voices. Thank you. Thank you.
أولاً مرحبا بالسادة والسيدات.
First of all, I must say welcome all of you, ladies and gentlemen.
أنا صلاح الدين آدم.
My name is Salah Eldin Adam.
لاجئ بالمملكة المتحدة.
I came to the United Kingdom.
وصلت إلى المملكة المتحدة في 4 أبريل من العام الماضي 2024.
2024 on the 4th of April.
ولكن للأسف أنا من أحد الأشخاص الذين تعرضوا للسجن عند وصولهم من المملكة المتحدة.
Fortunately, I am one of those people who has been imprisoned in the United Kingdom.
والتهمة كانت بسبب الهجرة الغير شرعية أو الدخول إلى المملكة المتحدة بدون أوراق ثبوتية.
And the allegation was that I came to the United Kingdom illegally without any proper documents.
بعد الاتهام مباشرة فذهبت للسجن فقضيت 4 شهور من الحكم اللي كان 8 أشهر.
Straight away they took me to prison and I had to spend 8 months.
فدي كانت صدمة كبيرة جدا جدا بإنه يكون لي لاجئ فهدف إنه يوصل للمملكة المتحدة من أجل الأمان.
That was a great shocking for me to come to the UK hoping for the safety and the security to find the journey has ended me into prison.
فكانت لحظات صعبة جدا جدا يعني خاصة في المرحلة الأولى.
It was a very difficult time for me, especially at the first impression I had from the UK authority.
خاصة إني مضيت يعني 3 أشهر من غير أي حكم ولا أي فترة يعني ما كنت أعرف يعني المدة اللي أقضيها في السجن.
I stayed 3 months without any charges at all, without knowing my fate or where it's going to be, where my future is going to be.
حتى يعني ما في أي معلومات من المحامي اللي كان يعني قابلته في المرة الأولى.
The lawyer I met him at the beginning has never ever given me any indication at all about the case, never informed me anything at all.
فحتى خلال الفترة بتاعت ال3 أشهر كنت يعني خاصة في الأسبوع الأول بحاول ألقى طريقة أقدر أتواصل بهم مع الأشخاص اللي في الخارج إنهم أخبرهم إني أنا في السجن لأنه ما في حد يعرف إني أنا في السجن. فكل الناس تعرف إن أنا خدت الرحلة للمملكة المتحدة ولكن فجأة اختفيت يعني ما في حد يعرف إني أنا وصلت.
The first week I tried to get in touch with the people I know outside, but I lost the contact because I don't know where is my future is going to be. Nobody knows anything at all about me.
لأنه السبب ما مسموح إنه أي أحد يأخذ هاتفه معه في السجن. فلذلك ما وجدت طريقة يعني إني ألقى يعني رقم حتى أخذه عشان أتواصل. لكن يعني بحسن الحظ جونا مجموعة الدعم الكابتن فهم ساعدونا في إننا كيف نحصل على الأرقام للناس اللي في الخارج إنه نبلغهم ونطمنهم عن مكاننا في السجن.
Some supporter came from outside just to secure our mind about how to contact with your relative out of the place where I am.
فحتى قدموا لنا الدعم يعني كل الدعم المعنوي لأنه
So
كنا
they
محبطين
supported
جدا جدا
us
يعني.
physically, mentally, emotionally as well.
حتى الدعم المادي فمنذ وصولنا يعني ما كان في حتى ملابس إنه نرتديها في السجن فهم ساعدونا يعني في ببعض الملابس والأحذية.
We didn't have even clothes to put on during the time while we were in the detention. However, the supporter team has provided us with clothes.
فكان التحدي الأصعب بعد المرحلة دي كانت كيف أنا عارف إني أمضي كم فترة في السجن ولا أطلع 200. فدي المدة اللي كنت يعني في خلال ال3 أشهر كنت منتظرة. فحتى أنا المحامي قدرت وصلت له عن طريق مجموعة كابتن سبورت أيضا.
Yeah, through those supporter, I came to know how to contact my lawyer.
حتى ما في رسالة جاتني من المحامي أثناء الفترة وحاولت أراسله لأنه كان معي ورقة فما جاني أي رد من ناحية المحامي.
Although I have tried my best from my side, I sent him a message, but no response.
لكن بعد الجهود المبذولة من خلال دعم الكابتن فهم قدروا يتوصلوا للمحامي بتاعي وحتى يعني حققوا فترة الحكم بالنسبة لي.
Captain Support has made the effort to me on my behalf and contacted the solicitor.
فكانت فترة صعبة وبعد الحكم في المحكمة كان النطق بالحكم 8 أشهر. وكان الصدمة أيضا يعني لأنه حتى إني كان فاكر بعد المدة اللي قضيتها 3 شهور إني أطلع خلاص لكن الحكم كانت 8 شهور فعلي إني أمضي تاني شهر إضافي.
I was charged for 8 months in prison and 1 month as an additional as well.
فكانت والله الفترة صعبة جدا جدا خاصة يعني بالنسبة للآمال اللي كان الواحد واضع إنه بعد ما وصل للمملكة المتحدة كيف يحققها. فبالنسبة كانت يعني اضطراب يعني في
It
فترة
was very
السجن.
hard for me to bear that in mind and accept the situation.
فحتى التأثير بتاع السجن ممكن يكون مصاحب حتى في الخارج بعد الخروج.
Yeah, I did have impact for the period I have spent in the prison when I got out of the place.
في بعض الأشخاص ممكن يتخطوا المرحلة، فأما البعض ما حيقدر يتخطى لأنه صدمة أول ما يصل لبلد يلقى نفسه إنه في السجن من غير أي جريمة ومن غير أي سبب.
Some people can absorb that shock and other people cannot take it, especially when they have a plan in their head about the future, which is going to be open to them when traveling to a country like UK.
حتى في مثال بعض الأصدقاء اللي كانوا معانا في السجن حتى بعد خروجهم من السجن فما زال متأثر يعني بفترة بقائه في السجن، حتى متأثر من كل شيء، حتى من الشرطة من أي شيء يعني، حتى ما يقدر يطلع برا الفندق عشان يقدر يواكب حياته اليومية.
I have a friend who's really still suffer until now from the impact of being in the prison. Even until now, he can't go out, he can't look at any policeman, he can't be open with the public.
التأثير ده يعني ممكن يكون له النقطة دي ممكن يكون لها تأثير يعني سلبي جدا جدا على حياة أي إنسان يتعرض للسجن يعني، فممكن يصل لمرحلة بتاع الإنسان يفقد تاني رغبته في كل شيء في الحياة. حتى لقينا أشخاص صرحوا بأنهم يعني خلاص يعني ما أظن في أمل للحياة بعد وصولهم وجدوا أنفسهم في السجن.
Some people can lose interest in life after arriving to the UK and they found themselves ending in a prison.
أخيرا رسالة أخيرة ممكن أنا أوجهها للسادة المحامين وحتى المنظمات.
I wish and I would like to say some few sentences to the lawyers and the barrister who attending courts.
لأني لا أرى يعني حق الهجرة الشرعية هي جريمة، فكونه إنه الإنسان يتقاضى في سبب دخوله للمملكة المتحدة أو أي بلد آخر بسبب الهجرة وطلب اللجوء والحماية.
If they charge me because I'm coming to asking for refuge and seeking security and then find myself became a criminal person, that's unfair.
فبتمنى إنه المنظمات تسعى في الأمر ده إنه يعني يزال هذه المقولة هي تجريم يعني طالبي اللجوء.
I wish hands to be together and we have to face the try to change or amend it or do anything really.
حتى المحامين يعني فبطلب منهم إنه يكونوا نزيهين جدا جدا ويعرفوا موقف اللاجئ إنه الوصل للبلد فيهدف لشنو، لأنه حتى أنا كان المحامي بتاعي ما كان يعني يعرف الأسباب اللي أنا جيت من أجلها، حتى ما كان يعني ما ساعدني في أشياء كثيرة، حتى الأقوال اللي أنا أدلت بها فما قالها في المحكمة بصورة صريحة جدا.
So I'm asking all the lawyers to be kind to the refuge person who come, especially on my case. My lawyer never even know why did I come here for.
وأتقدم بالشكر لمجموعة دعم الكابتن الذين هم يعني ساعدونا كثير جدا في تخطي المرحلة دي وفي مواجهة الصعوبات داخل السجن وخارجها.
Yeah, and I do thank all the supporters who gave us the chance to talk and express our feeling about what's going on.
شكرا جزيلا.
And thank you so much.
Thank you very much, Salah, for sharing your experience as well, and I'm sure that that's going to be something that we'll all take away from here, our own responsibility to make sure that we do what we can to challenge this ongoing practices of the Home Office. So obviously you've heard from Salah about his experiences and how important it was when his lawyers failed him, that there was an organisation there that stepped in to help. And our next speaker is Basma Kamel from the Refugee Legal Support. She's the outreach officer for that organisation, who does work very closely with newly arrived people, explaining giving advice and access to information about the asylum system and providing vital release support, because of course the problem is not just when the person is detained in prison, but what happens when they come out, and the ability to survive that process and to try to recover from it is obviously critical for the person then to have to navigate the legal processes and access essential services that they need. So Basma, I think you're going to give us an outline of what your organisation does and how important it is.
I hope you can hear me. Thanks, Salah, for sharing your experience, and thanks, Becky, for sharing your work and research. And I advise all of you to read the report. So today I'll speak about the work we do in refugee legal support to support people in prison and post-release. And as Salah mentioned, that the experiences in the prison where we were writing this report, we interviewed several people and they shared their experiences in the prison. And of course, as you heard from Salah now, lack of communication from the lawyers and like not really understanding why they are in the prison or the charges they are facing. And of course, one of the main challenges is the language, as people receive letters written in English, and some letters are like written in legal language where people not easily can understand, and this leads to isolation and confusion in the prison. The work we do also post-release, for post-release support, we try to do as many people being released homeless because there is no immediate support or accommodation provided to them. And of course, lack of the information about these people can access asylum support. After release being homeless, and we try to assess them in accessing asylum accommodation. Recently, many cases been released homeless because their asylum claims has been withdrawn by the Home Office because the Home Office tried to contact them where they don't have a fixed address for them to receive letters from Home Office and inform them that either you're invited to an interview or they just decided to withdraw their claims. So also this leads to homelessness of the people after being released. So we try to reinstate the applications again and try to assist people in accessing asylum accommodations. Also, one of the challenges that people face after is also finding the stigma and the trauma for even staying in asylum hotels, because people working there, they know that they just got released from the prison, but they really don't know why they were in the prison. And this makes people, again, isolated. And of course, it affects their mental health, as Salah mentioned in his experience and his friend's experience, where the person is still isolated inside the hotel and fearing to face people outside. Of course, having the burden of criminal record afterwards, where people, even if they got refugee status, they still have this in their criminal record. So this not allowing people to find easy jobs or even accessing education and further settlement in the UK. And I'm sure many of the people attending today are from different sectors, from the legal sector or NGOs. So what we ask the organizations here, as at the moment we are providing legal support to people being released, but also there's other essential services that needed, as Salah mentioned. It's also mental health support needed. There is essential items that needed. Also, we need all the organizations to build network to be able to assist asylum seekers once they're being released. Also for legal professionals, also to spot trafficking indicators and raise defenses while they're working on these cases, and communicate better with their clients and try to understand why they're coming to the UK, and also to resist the quick guilty pleas under pressure, where people has to plead guilty because they needed some, to get shorter sentences, and they just want to get out of the prison. And this really is not in the case, and we are calling the professionals to maybe try to share this with the clients. Refugee Legal Support will be organizing training in person and online soon for also legal professionals and lawyers to share our work in the criminalization and try to have a bigger network where lawyers can work better with their clients and try to assist them in these charges.
Thank you. Anyone? So we've had a very good insight into the problems, and what we're going to move on to now with the next speakers is what steps have been taken where lawyers have been able to successfully, in some regards, challenge this experience of prosecution, particularly in the context of the prosecution of children. And Michela Carini, who's a solicitor at Bat Murphy, as I said at the outset, is going to talk to you about the cases that she has been involved in. And she'll cover both judicial review and also some cases that have taken place where we've challenged the decisions in the magistrates' court itself. And so that will give you a perspective on what kind of legal strategies can be successful in this way. Michela has a lot of experience in civil and public law actions against state authorities and is particularly committed to working in fields of unlawful detention where vulnerable adults and children are mistreated within that system, and it also has an important part of her work working with women and with victims of human trafficking. Michela.
Thank you, Steph. So yeah, I was going to speak quite briefly about legal challenges we brought to the prosecution of children for immigration offences. Those offences are primarily the ones that Vicky was talking about, so Section 24 and Section 25. So I'm going to focus primarily on a judicial review that we brought starting in 2023 against the referral for prosecution, the charge and conviction of age-disputed and accompanied children for illegal entry and facilitation. Again, those offences we've been referring to. The challenge started as an individual challenge for a child who was age-disputed, and all of these things had happened. In fact, the case came to us when he'd in fact already been released from prison, and I'll explain some of the complexities that that brought. But it then became quickly a challenge against the Home Office policy, as well as CPS decisions, and it was joined by several other cases. Just to give you a kind of overview, the case settled earlier this year, so about 2 years after we first issued it, and just before going to trial. So the Home Office accepted effectively that they'd acted unlawfully and agreed to change their policy, which they've now done. And the CPS also made some significant concessions that I might be able to touch on. So identifying the challenge was complex for a number of reasons, and I might just use AGB's case. That AGB is the first client we had, and I refer to him as AGB because he's, for obvious reasons, been anonymised in all proceedings. And he'd left, well, he'd actually forcibly been transported from Sudan to Libya to be recruited as a child soldier. He then managed to escape, but was trapped in a warehouse in Libya for quite a long period of time, where he was subjected to forced slavery. Again, was able to escape and eventually made his journey through Europe. And when he arrived in the UK, he was transferred to Western Jetfoil, which Vicky was touching upon, and there he stated he was 17, but was subjected to an assessment under the Home Office assessing age policy, and specifically a provision within it, which is the significantly over 18 provision, which allows two Home Office officers to assess someone as being over 18, so an adult, if their physical appearance and demeanour strongly suggest that they're significantly over 18. And that really, we realised, was the crux of the problem. A number of people were being assessed as being over 18, and in fact we know, and Maddie will say a bit more about it, that the rate of error in those decisions is very high, and there's now statistical evidence of that. There's something between 50, 60, sometimes over 60% on the data of children who are assessed as being adults and then go on to receive proper Merton compliant local authority assessment that confirm that they were in fact and are children. So AGB was assessed as being over 18. It was assessed in fact as being 21 rather than 17. And then I just I'm not going to be able to go through all of these decisions that followed, but this is just to illustrate from that initial decision, he was then effectively treated as an adult throughout. in that original challenge, in a way that was kind of unquestioned by all these other state authorities, which is obviously hugely problematic. In AGB's case, the Home Office actually didn't inform either the police or the CPS that he was age disputed, so they just provided the evidence with the date of birth the Home Office had assigned to them, and that's the base on which the CPS made the charging decision. Really amusingly, the Home Office, in their initial defence, told us that they didn't have any duty to inform the police and the CPS that someone was age disputed. They've now changed their position and changed their policy, but just to kind of illustrate sometimes how hard it is really to get over that hurdle. And then the CPS charged, in some other cases that joined that case, charged knowing the person was age disputed. So the CPS decision making was also subject to the JR, and the CPS was a defendant. They were then transferred to the magistrates' court, and one of the things that was really problematic is that they were allowed to enter plea as adults in the magistrates' court, despite stating again that they were children, including AGB, and then they were remanded into custody, and that's where a number of children, we know, and Maddie will talk a bit more about that, ended up for significant periods of time in adult prisons. AGB was in prison for about 3 months, but some of my other clients are in prison for longer periods, up to about 6-7 months. And they were forced to share cells with adults. AGB was, during that period of time, was racially abused and assaulted. So obviously really horrible things happened to them during that time. Throughout the whole time, he kept maintaining that he was a child, but simply didn't have access to a proper age assessment, which should have been the case at the beginning. And so eventually, how the case concluded in the criminal court, the first instance proceeding, was with AGB, who had by then entered a guilty plea, accepting to be sentenced as an adult, simply because that was the only way he was going to get out of prison. And with the judge, in fact, remarking that there was a live age dispute, but he was sentencing someone so that they effectively just couldn't get out, and he had by then spent on remand a longer time than the sentence he would have had to serve. On release, he was age assessed by a local authority as being 17, and so a child, and he was taken into care as a child. And then eventually, in fact, during the course of the JR, we at the same time brought a criminal appeal to quash his conviction in the Crown Court, which was successful and has been successful for a number of other people. And we have still some outstanding cases, including one in the court of appeal that hasn't been heard yet. As a result of the JR, as I said, the Home Office agreed to change their policy. That's the assessing age policy, and they, oh, sorry, that's not screen. There was sort of various iteration of it. I don't really have time to take you through all of them, but I put them there. The latest new policy effectively provides that if someone is age disputed and identified for prosecution for an immigration offence, they first need to have an abbreviated age assessment. There are issues with that, but as far as we know, we don't know of anyone who's been referred for prosecution after about April 2025, so round about when we settled the JR, which is a good result, but that doesn't mean there might not be problems with the policy in the future. And the CPS also accepted and made concessions on a number of their decisions, although so the only thing they really conceded on their policy is that they would review them, not that they would change them, but they accepted, importantly, that it wasn't and hadn't never been in the public interest to prosecute our clients, and also agreed to support their appeal against conviction, or effectively not to oppose them. If I have like 1 more minute, I'll just say
Keep going. You've got
a couple of things.
You're fine.
On how that changed the practice in the criminal courts that then Henry might be able to add to. But even for people, once we brought the JR and sort of as the JR was kind of settling, some children were still being referred for prosecution and charged. But particularly in Kent, the magistrates' court started changing what they were doing. And so instead of remanding people in custody, they started bailing or remanding to local authority care so that a proper local authority or NAB, so the National Age Assessment Board, assessment could take place, and also so that they could go through the process of properly assessing age under Section 99 of the 1933 Act. And so there were then what were effectively fact-finding hearings about age in the criminal court, so that the court could be satisfied of what age the defendant was. Staff was involved in a number of those cases, including in cases where the assessment of the NAB, which is a Home Office board, were contested and rejected by the court, and where the court then concluded the defendant was a child. And as soon as, well, not as soon as, but following that decision, the CPS then dropped charges kind of consistently with that admission that it was never in the public interest to prosecute someone for that offence who is a child. Obvious reasons. And the Home Office and the local authority then kind of, is my understanding, in most cases ended up accepting, maybe other than
One is still outstanding.
yeah, still outstanding, that they needed to withdraw their decision, or that their decision were incorrect, and the age of the person who had been a defendant was that determined by the court. So that's kind of one thing I wanted to say about this, is that it took a really long time even just to identify the challenges, and it was a kind of huge kind of team effort from a number of organisations, a number of lawyers and people working together, which include Maddie and also Vicky, who was at the time for her research sitting in the criminal courts and provided witness statements in a number of these cases, especially in the magistrates' court. Some of you might know, but it's quite difficult to really know what is happening because they're not always transcripts or recordings. So that was really instrumental. And it's also just a testament to the people who went through this, for some of them having been released and their conviction quashed, that they wanted to carry on the challenges so that the policy would be changed, which it has now.
Henry, you were going to add something about the appeal process, or how the process for overturning convictions.
Yeah, I can add that, but can I just say that when I came here, I wasn't expecting to contribute, and I was going to be in the audience, so I'm completely prepared a bit. But can I just start by saying this? I became involved in the judicial review because there are two defendants, the Home Office and the DPP, the Crown Prosecution Service, in effect, and because I have some experience in criminal law, and I've done a number of cases involving representing people who, defendants who have subsequently been agreed to be victims of trafficking in the Court of Appeal, it was thought that maybe I could contribute to that. But I haven't actually done any of these immigration cases. And I was deeply shocked to find that there was an offence under the Immigration Act, which effectively overruled, well, first of all, Eldin, which Steph has mentioned, which then led to the implementation of Section 31 of the Immigration and Asylum Act of 1999. And I had naively thought that that was still good law, and it was originally challenged, as has been explained, and then they tightened it up so that we have now the extraordinary position of somebody who can commit a criminal offence simply by arriving unlawfully, in other words, without getting a visa. Well, how the hell are you meant to get a visa if you're in the situation in which most people find themselves? So this really was a bit of a shock to me, and was a voyage of discovery. I then found that that a number of the cases that arose here came about because the solicitors who were acting for people in the magistrates' court really didn't have any idea about the relevant provisions. What was happening was that the Home Office people were conducting these completely inadequate and frankly racist age assessments, and then referring them to the CPS for prosecution, and the CPS were effectively just adopting the age assessment which had been carried out by the Home Office. So effectively, They weren't conducting their own independent assessment. They were just relying upon what was said, and it was barely challenged. And you found cases of people in the magistrates' court saying, well, actually, hello, I'm 16, I'm 17, and I've always said that, and I'm going to continue to say that. Notwithstanding that, they get committed up to the Crown Court in some cases, and eventually end up pleading guilty, because the only way that they're going to be able to get out of prison for a proper Merton compliant age assessment to be conducted was by being released from their prison sentence. And so people were being wrongly incarcerated and then ultimately pleading guilty to offences to which they should not have pleaded guilty, because in the case of children, it is the Crown Prosecution Service's policy not to prosecute for these offences if you're a child. So there are a whole cohort of people who should never have been prosecuted in the first place. The result of the JR is that there are people now, well, as part of the settlement in the JR, the CPS agreed that they would not challenge appeals against conviction, even though people have pleaded guilty. Which leads me to the point that I think Steph wanted me to address, which is a very small, limited and narrow point, which is, what do you do with somebody who's pleaded guilty? Well, in the Crown Court, it's actually, if you're committed to the Crown Court for trial and you plead guilty in the Crown Court, it's fairly straightforward, because if you shouldn't have been prosecuted at all, then the jurisprudence of the Court of Appeal establishes that you can challenge it. There's a technical problem in the Magistrates' Court, which is that Section 108 of the Magistrates' Court Act provides that you can't appeal to the Crown Court if you have pleaded guilty. So your choice is either to appeal by way of case stated, but there's a very strict time limit on that. You have to apply for case stated within 21 days, or you appeal to the Crown Court. And in fact, one of the submissions that was made in the JR proceedings was that those people who had pleaded guilty would have to go to the Criminal Cases Review Commission, because they were barred from their case being heard on appeal by the Crown Court. Anyway, mercifully, I think we've put that to bed, and there are certainly two cases in which the prosecution didn't, as they'd undertaken to do, did not oppose the appeals, and effectively, of course, the answer to it is that if you shouldn't have been prosecuted in the first place, it's an abusive process for you to be, the prosecution to be continued, and it's really on that basis that ultimately the convictions have been quashed. Can I just finish with two remarks? Okay. Firstly, I'd like to pay tribute to the work that Steph has done. She's an absolute powerhouse in this field, and she's been working in this field for a long time, and I saw her working at close quarters in the JR. I'm not really a JR specialist. I got brought in really on the false pretenses, really, just to sort of make it look like there was a criminal practitioner there, but she's magnificent. And the second point I want to make is this: we live in very toxic times at the moment, and it's incredibly important that the sort of work that you are doing, these people, everybody in this room, these people on the panel are doing, is maintained, because we are really under pressure, and it's so important that people ensure that asylum rights are properly respected, and we've got a fight on our hands, and we're going to win.
I'm going to ignore what Henry said about me, except to say, as you can see, it's a team effort, and you don't get a success like this without a team. And the reason why everybody is here, because all of these different people and their organisations play a key role, and without any bit of it, it wouldn't work. But just a couple of things that Henry said, just so you've got a context. He said that the age assessments were racist, and there were two ways in which we had very powerful evidence about that. One was the very stark fact that at the time, 25 children who were wrongly prosecuted as adults, I can't remember, it's 82% on the Home Office's own figures, were from Sudan and were Black African children. And so the statistics spoke for themselves, as well as the fact that when you look at those age assessments, and maybe in this room that's part of your practice and you see them, it was absolutely apparent that they were using racial profiling to identify the characteristics that they said indicated that these young people were adults. And because they were young black males, there was a clear adultification, which is a recognized structural discrimination that takes place in lots of contexts, and they are absolutely fed through those age assessments. And the second thing I just wanted to say is that the position for criminal defence lawyers in the magistrates in Kent is deeply difficult. However difficult our job is, their job is infinitely more difficult in terms of the resources that they have and the pressures that they're under. So there's nothing that we would want to say that criticises them. The truth of the matter is, and again it was recognised in 1998 by Lord Justice Simon Brown, I'm troubled about the prospect of busy magistrates trying issues as difficult and as sensitive as those which arise under Article 31. And even in a subsequent case in 2009, which was about prosecution, wrongful prosecution of a child, another High Court judge recognised that these issues, complex as they are, should not be being dealt with in the Magistrates' Court. They fully recognised that if the avoiding of not imposing penalties is to occur, you've got the Home Office has to have the responsibility, because once the prosecution has occurred, even if you stop it, there's already disadvantage. And so I think one of the success stories that I would say about this litigation is that, in the way that Michela said, is that whilst we got the big victory in the judicial review, we were able to go to the Magistrates' Court to work closely with local solicitors and to use our expertise. We all know, if we do age assessments, how challenging they are, the need to get expert evidence, the sorts of material that you can get to prove or to establish age that we do on a daily basis. That's not what busy criminal practitioners are doing. And so we were preparing the cases, and we were fortunate to have a humane and decent independent judge sitting in Kent who each time, despite having a 90-page NAB assessment, and I don't know if you've seen them, but what the criticisms that they made of them were really important, that they were not demonstrating that they were even applying the best in benefit of the doubt principle. So foundation in that area, they weren't doing it. They were adopting culturally specific and discriminatory approach to assessment of the person's account. They were going out of their way to find evidence to reject age and disregarding evidence that was supportive of age. And that ultimately they weren't adopting the kind of child-centric, trauma-informed approach, even though, of course, the Home Office has policies that say they're so. So it's a complete takedown on 3 occasions of those disgraceful assessments. And we obviously need to do something to bring that together. So that's the next report. There has to be in there, because those 3, there were witnesses from the NAB assessors came and were cross-examined, and in each one of them, they failed fundamentally to demonstrate that they'd adopted a fair and rational approach to age assessment. And so that was an important thing, and those decisions are important for wider than just criminal prosecutions, and we need to get them disseminated. Anyway, we now are fortunate to have Maddie, who's going to is going to make the last contribution, but nonetheless one of the most important one, because she has been, whatever we were saying here, who's the one, but Maddie has been incredible in her persistence and dedication to this issue, and in bringing it to lawyers and bringing it to public attention. And so, whatever the magnificence is, it's shared very widely.
Thanks, Steph. Yeah, definitely very much a joint effort. So I just wanted to talk a little bit about sort of how we got here in relation to the judicial review and what we need to do going forward. So, as Michela touched on, the fundamental problem in relation to children being prosecuted is the fact that the Home Office has and continues to operate a deeply flawed policy of determining the ages of individuals when they arrive. They are coercive interviews. As Steph's mentioned, young people are racially profiled, and today we've had, frankly, a total lack of substantive engagement from the Home Office on this issue, despite cold hard evidence that these age determinations are flawed. So I put some stats on the screen. We do mention them in the report, but as you can see, deeply flawed, huge numbers of children ending up in adult settings, adult prisons being one of them, and we continue to work on this issue. And today we've worked with over 2,600 children, and that number rises every day. So this policy of determining age gives rise to a number of very egregious experiences that children are having. So Manston, a detention facility, hotels, camps where there are major safeguarding issues, and then some of the most egregious being, as we're hearing today, children in adult prison, but also increasingly children in immigration removal centres facing removal. So we've touched on this a little bit before, but just to give you the full picture. So it's actually now 30 children that we've identified. 23 of them are from Sudan or South Sudan, and all but one of those children are Black African in origin. And I really cannot emphasize enough, again, as Steph's mentioned, this is adultification. By adultifying children, you remove that inherent vulnerability that a child has, and that follows that child throughout the process of criminalisation, and is causing immense harm to children. And we really need, I think, when we talk about this issue of children treated as adults, need to be being very clear about what is actually happening, and that is a racist policy that is adultifying children. So we've talked a lot about, I think, or tried to talk a lot about collaboration. So ultimately, one of the biggest issues we've had and continue to have is how we're finding these children. And there are lots of different ways in which that's happened. So Vicky's sitting in court for months on end, referrals from solicitors in Kent, friends of people where perhaps the individual in prison has managed to call a friend or a relative and be able to kind of raise the alarm, and then a couple of instances where people contacted directly. But it's often been after a period of time, often perhaps even when prosecution has taken place. Most recently, children who are already in prison and children who have already been prosecuted. And what's so important within that is that, as has been mentioned before, you know, we need to kind of get in there at the earliest possible opportunity and work together. So where there is a criminal solicitor, it's not expected that perhaps they've got some of the knowledge and particular expertise that is needed. So those referrals to us, and then that we've been able to make onward to solicitors like Michela. So collaboration. And I think one of the points I really wanted to make clear here was perhaps it may not be kind of widely understood or known that it is sometimes the case that an individual doesn't know exactly what their date of birth is for a variety of different reasons, or doesn't have any documentary evidence to be able to prove that. And so what I guess I would kind of implore and encourage people to be doing who may well be encountering children whose ages are disputed and who are subject to criminal prosecution is to be inquiring and to consider questions regarding how old somebody is rather than dates of birth, and to be reaching out and accessing support from specialist practitioners and NGOs if you are unsure as to how to proceed, because it really is very much a joint effort that's got us to this point. I wanted to talk a little bit about the impact on children. Salah has talked himself about the impact that this experience has had on him and people that he knows. And that, of course, the experience on children is really significant. So we're still working with children who were prosecuted over 3 years ago. Very lengthy age dispute challenges. Some of them have been embroiled. There is one individual that we're still working with at the moment who is 2.5 years from arrival in the UK, and his age is still not determined, and that is very much due to how he was dealt with in the criminal process. And that essentially it's almost like the evidence is continuing to be stacked against him. So the earlier we can become involved, the better. Really lengthy times spent by children in prison, as Michela mentioned, the longest being 7 months for a 14-year-old child. And then, of course, the significant impact that this is having on children, in some of whom who are now adults, but they continue to be affected by that experience. Impact on asylum claim, delays in education, delays in employment or accessing training. I mean, the consequences, and I think Basma touched on it before, we know some because we're working with people, but we don't know fully the extent to which these prosecutions are going to affect people, and children 3 years later still being involved in complicated legal challenges to try and resolve the issues that have affected them. Again, Michela touched on it a bit, but sort of put between the sort of settlement of the judicial review and the change in policy, we did see that shift in Kent courts, but we have continued to see how where a child may be arrested from a hotel, so arriving, treated as an adult, routed into an adult accommodation and then arrested later, where children are ending up in courts where perhaps there's not been that kind of level of engagement or, I suppose, frequency of judges and criminal practitioners seeing children. The decisions that are being made have kind of taken us right back to the beginning. So working with children who have been sent into prisons from those hotels and kind of different approaches being taken. So again, kind of moving forward, I think what's really important and what we want to work on is taking a lot of the knowledge that criminal practitioners in Kent have developed and trying to bring that to people that are working around the country, because we know that people continue to be arrested from other parts of the country. We haven't identified another child since April this year, which is very positive. However, the new policy suggests that a child would be routed into an adult hotel prior to the arrest. It's still the NAB conducting the assessment. They are very problematic. There is lots to be positive about, but we really need to continue to monitor that policy. And if a child is picked up from an adult accommodation, they will be routed into a court system outside Kent. So we need to be hot in monitoring what's happening. And then really briefly, because I've taken this over time, there is a new bill which will possibly quite inevitably become an act later this year or early next year. And it contains 5 new offences that builds on the offences that were brought in by the NABA. So these offences are only going to target people who are forced to move or who are seeking asylum. They fit squarely into this kind of far-reaching narrative that previous governments and the current government have successfully kind of pumped out there, which is that people arriving are criminals and that they are illegal. So the offences are to do with the handling of sort of items, but also information. So could it be the case that sharing the location or the weather or a family member sending you safety at sea information would contribute to an individual committing these offences? And then one additional offence, which is the endangerment of life. So, for example, where an individual resists rescue or is coerced into doing so. And I think the point I wanted to make about that is that when France is not safe, when people are fleeing violence on those beaches and horrific living conditions in France, there are reasons why people are absolutely in need of needing to continue that journey. So there's a lot of work to do on these offences. We need to be monitoring them very closely, both in relation to children and adults. And I think what I wanted to just finish by saying is we need to continue to monitor the policy in relation to children, but we also need to be learning from how we've managed to kind of work together and navigate the issue for children and come up with some new ideas and resist the new offences and work on the issue in relation to adults as well. And then these are QR codes where you can find the 2 reports. Thank you.
So we have got time for some questions now. We're happy, obviously, to answer anything that's burning that you'd want to ask us, clarify anything, or come up with ideas or anything.
I'm Sarah Singer from the Refugee Law Initiative at the University of London. I wanted to thank all the speakers, a really incredibly rich panel, and thank you so much for sharing all of your insights with us. I had 2 questions. The first one is kind of perhaps a bit broader. I found it really interesting that you've been able to identify some patterns in who was being targeted for prosecution. Is there any kind of overlap or similar pattern that might with the people that are being targeted for removal back to France? So again, it's like a relatively small number of people that are being targeted. a lack of clarity over how those decisions are being made, it might be something that's kind of beyond the remit of the panel as it is at the moment. The second question was, Basma, you mentioned one of the strategies that you recommended was resisting the guilty plea. And I think colleagues made it very clear how resisting a guilty plea is very beneficial for age-disputed people. What other situations would that be beneficial? Because from my kind of reading of the statute, there's no other defences, is there? So I'd be really interested to hear your thoughts on that.
Great. Maybe is anyone wants to answer the first question? I will answer your question now if then someone else will answer the question. But I mean challenging the guilty pleas because from the interviews we made with people and also from other people we are supporting in the prison when they say we get advised like to plead guilty because the lawyer says that would give you like less sentence and you will be free, or being advised by other people in the prison. Even some like the lawyer is doing the work to make some defenses, but then the person comes and says like I will plead guilty just to get released early. I think if there are more defenses made and some people want really, and they don't think they are guilty of arriving to seek safety in this country. And if there are more of these pleas that would be presented, I think there would be more stronger defenses and challenging to the whole like legislations and laws, I think.
And I have there's a box on one of the pages that I now can't find that talks about a case in which we tried to bring the Article 31 challenge against the decision to prosecute. So that's one example. I think, and this is what Basma was explaining well, is there's potentially some misinformation or miscommunication of the intersection between criminal and immigration law on behalf of judges and sometimes criminal defence solicitors, where they say you'll surely be deported if you get an over 12-month sentence, when that's not always the case, given that quite a lot of people have very strong asylum claims. I think there's also just pointing out that it's not necessary that you'll definitely be deported if you get over 12 months. And then, yeah, as Steph was saying earlier, the potential for bringing in a challenge on the basis of being a victim of trafficking.
Yeah. I mean, the problem is there is no substantive defence to the main charge that's used. So you have to take a systemic challenge, if you like, victim of trafficking.
Yeah.
Or even in the case of children, of course, it's simply that there is the policy of the CPS not to prosecute. But the problem is once you are prosecuted, even if you are a child, that doesn't itself provide you with a defence in law. I mean, you can challenge it, but on the basis that you're a victim of trafficking, therefore shouldn't be prosecuted. But that goes to the base decision as to whether to prosecute, as to whether you have actually a defence, a substantive defence.
Yeah, so that is the case. So on Article 31, there was a legal case in 2023. It's called Mohammed Ashari.
From page 11.
Where it was argued that you could have a defence of Article 31, but because the statute is silent, therefore they treated that as not implementing the defence. That was the solution after a DME. They would make a specific defence. That hasn't happened. And so the Court of Appeal said because it would need express provision, it's relevant only to the CPS's exercise of discretion as to whether to prosecute or not. So it's obviously a complex defence to show that you've come directly. That is not interpreted strictly. The DME and the other cases subsequently recognised that asylum seekers can make a rational choice about the country that they come to, and they recognise that could be family members, it could be culture, it could be fear in the other country, and obviously no safety in the other place. So that's often forgotten. Refugee Convention does not require a refugee to seek asylum in the first country of asylum, but so that can be made in representations to the Crown Prosecution Service, but it's something the Home Office themselves should have been considering. It is possible to replicate a judicial review if you can demonstrate, as I believe is the case, that there's no systematic consideration of whether Article 31 applies. But it's actually quite difficult just to do that on the documents because you need to advance a case and you need to put forward a case. They can say you've been in France for however you came from France, France is safe. that's not that's what they say, and that's all they say, and they don't go into it. And so you often have to do it retrospectively because it's not properly dealt with when they decide who they're going to refer for prosecution. And trafficking is a defence to Section 24 for the arriving, but not to facilitating. So in the case that we were talking about where there has been a conclusive grounds decision now in that child's favour, the prosecution was ended because of the acceptance by the magistrate that he was a child. But we had an abuse of process argument that we were also hoping to, well, we had our backup argument. If they didn't accept him to be a child, the CPS had not considered trafficking, and he had at least a prima facie case that he was a victim of trafficking. Again, that would go to the prosecutor's discretion because he was also charged with Section 25. We didn't need to do that because he was accepted to his age, but there is a judicial review that is being done by DPG that we're doing with Shushin Lewis, the junior. I'm working on that case where we have challenged at a systems level the failure to carry out any proper screening. We haven't got permission on that, but I think the important thing about these cases and the very important thing about the AGB case is that the primary defence of the Home Office and the CPS was this is not appropriate for judicial review. But they took a load of time points and all kinds of stuff like that. Any point they could take, they avoided the substance, they did. But the primary argument was you run this in the magistrate's court because it's very rare to be able to bring judicial review where there's an ongoing prosecution or there's been a prosecution, etc. And the really important thing is that despite that, they conceded it. And we also subsequently got a very good judgment because the CPS resisted costs and the judge set out why it was appropriate to bring a claim against the CPS. And I don't know whether we can distribute that, but it was very nice reading it because it made it clear that this is it's a rare jurisdiction, but it's an important one where there is systemic failure. I think Michela also has a good example of how there might be challenges in the magistrates as well.
Yeah, I was just going to say on resisting guilty pleas, like because these cases are so complex, even if, and Steph was saying, trafficking as a defence just a second ago, because people are selected quite often on the basis that there's been some photographic evidence or sighting of them steering the boat and being at the tiller. I think it's really important that a guilty plea is not entered until effectively everything has been really thoroughly analysed, because there are cases where then, I have a specific case, for example, where it went in the magistrate's court to a new hearing on the basis for plea because the defendant disagreed about the basis in which they were saying he'd been steering the boat and been charged then with Section 25 together with 24. And that at that hearing, then the CPS had to concede. Effectively, he was saying, I was photographed by the tiller, but I wasn't steering the tiller. People were taking turn, but I was just by there because water was coming into the boat and all sorts of reasons. But once it wasn't viable for them to go ahead with Section 25, they just effectively dropped all charges because it's fairly rare that people proceed just on Section 24. And so in terms of resisting guilty pleas, even where there isn't a really obvious defence, there are sometimes other ways. And so if people really kind of go at it and do a really thorough job before advising someone to enter a guilty plea, sometimes there are ways.
In most cases of adults, just slightly different with adults.
Yeah.
That if someone is, most people who are identified as steering the dinghies are initially charged with both Section 24 and 25. And in the magistrates' court, generally they plead guilty to the illegal arrival offence, but not guilty to the facilitation offence. And in most cases, that facilitation offence is dropped, but the illegal arrival charges continued.
Which in itself is oppressive.
Yeah.
If you're choosing between a sentence and hoping to get some, I don't want to face a charge that's a maximum life imprisonment when you could get an 8-month sentence and you probably get out. But on the monitoring point, one of the concessions that was made in the judicial review was that the Home Office had been failing to monitor the prosecutions, and they were therefore not able to have it. They've got a fundamental problem with their inability to monitor the numbers of people who claim, who say they're children, they reject and then go on to be found to be children. They do not know how to do that. They haven't got that information. And that's why the reports that Humans for Right Network and others have done have been so important, because that opened it up. Through the judicial review, the Home Office conceded on their own inadequate statistics that the statistics we have are likely to be correct. That's why we know 60% plus are not accurate. But they were not monitoring, which is also why they didn't pick up this very stark race discrimination with this overwhelming number of young people being of Black African origin, primarily Sudanese. And they've got no explanation for that either. So obviously, discrimination laws, if you've got no explanation, then the inference is that you're discriminating, but they don't seem to recognise that. But it is an ongoing issue, so they conceded in the JR Section 149 breach. So whilst we can do the monitoring, it's important to do so, because that gives us a basis for saying there are people here with protected characteristics who need to be monitored. And I'm sure that's happening with the French removals, that they're not properly monitoring it. And, you know, we'll be doing their job for them, but we need to do so. Ollie, you've got your hand up.
Have they committed to putting in a monitoring system, like they committed in DMA in 2020 and then never did?
They have done that, yeah, they said they would. Yeah, but that'll be the next judicial review, because they won't be doing that. So your hand up.
Just wondering, in terms of resisting refugees, you're probably realistically going to be looking at Germans. So
Yeah.
I don't know if you've got any suggestions about how to deal with bail, and whether there are applications you can make which are successful.
Vicky?
Bail is unanimously denied in all of the cases that I watched, which was 125 hearings of 90 people.
Yeah, I suppose there's the interconnection, isn't it? What's the defence you're going to have? Because the assumption in the magistrates' court is it's strict liability is section 24, so you've got no defence. So I think it has going to be related, and you can change their practice. It was that universally all the disputed children were being remanded into custody and spending long periods of time in prisons in various places. But once there was legal argument brought, then they were bailing them to local authority care. So I think you obviously have to have that combination. You have to be able to show the magistrate that there's some defence, there's some argument here, and I think that would.
Yeah, for adults before the NABRA offences, so the earlier cases, they were granting them bail, but then after the NABRA offences, for some unknown reason, they just say that they don't have enough, that there's no ties to the UK, even in cases, and the first report goes into this in a bit more detail, even in cases where there were family members saying that they would give some sort of surety and accommodation, they were still denying bail. On the basis that they were at flight risk because they'd already committed a migration-related offence, and so what was to stop them getting on a lorry and
going back to France?
That's honestly the logic.
I think probably crazy. Sorry, yeah.
Yeah, I was just wondering, I'm an ex-immigration lawyer, shocked like.
You're going to say officer, I was going to.
No, lawyer. Shocked like Henry, completely sympathized. Ademi is gone, oh my God. Like, you know, but what made me think was, is it possible to imagine a challenge to the UK in the European Court of Human Rights? I mean, I know it's not a great setting at the moment, but where somebody insists, or a criminal lawyer helps someone to insist, okay, I do have a defense. It's section 31 of the Refugee Convention. Okay, it's not going to get you out of prison. So it has to be somebody that you've explained that to. The criminal lawyer says, it's not going to work. But you take it right up, and then you say there's no defense, and it's against the Refugee Convention, and take the UK to court. Is that possible?
Well, right now it is. I won't be able to say that it will be in 5 years' time because there's the mad dash to escape the ECHR. But I think in principle, yes, you know, there are cases in which Strasbourg, when they're looking at detention, for example, of asylum seekers, they emphasise the need for a protective environment on reception conditions, etc. There's a lot of cases of damages and findings of Article 3 mistreatment, especially for the detention of children, etc. So I think it's definitely something that can be considered, and how that international law at that level has to be interpreted consistently. So I think it's possible.
It escapes the pressure on, I mean, what I was hearing is the pressure to plead guilty because then you get out. Okay, supposing you say, no, I'm not guilty because of the Refugee Convention, that's what I believed, which is what most people do believe, actually, when they come here. You're not going to go to prison because you have a good defense. So if you use that knowingly, knowing that it's not going to get you out in the long term, but that you were going to make history.
I think the issue though, and
This is why bail is
so important, because where a person's in prison, so people are arrested and then they're remanded straight to prison. So if a not guilty plea is discussed, the toss-up that people have explained is, if I plead not guilty, I'm going to stay in prison longer than I would if I pled guilty today and then was sentenced. So I think bail is an area that really needs focus, because perhaps if people were not in prison, there may well be somebody who is, willing and able to pursue.
Well, you could do it the way Ademi did it then, and do it after you get refugee status. You just want to appeal your conviction.
Yeah, that's part of what we've been doing.
It might also be that in different areas of the country they're doing it differently. So this is our experience is mostly from Kent, because we was been mostly supporting people in HMP Elmley, and I was observing it. So it's unclear, and there's been one case at least in the Midlands where someone was granted bail, but so our monitoring picture is a bit more patchy outside of Kent.
Any other questions? Okay, well, as you can see, we've got our work cut out, and if we're going to follow Henry's indication of saying we can win this, then the collective effort needs to continue. But it is an ongoing fight for what is actually fundamental to any human rights framework, because if you cannot move to another country when your human rights have been violated, which I'm sure was the case for Salah, that he came here expecting to find safety and security. If you do not honour Article 14 of the Universal Declaration of Human Rights, and you do not honour the recognition that every human being has an entitlement to core irreducible minimum rights, and if it's not provided by their state, they can come to another country. That's the foundation principle of universal human rights, and it is now pretty much dead, except to the extent that we can keep it alive by the way in which we're both challenging this in court, but also providing the support that you've heard and the research that is being done to keep this issue as in the public domain. And I'd encourage all of you who have the means, either through being a lawyer or getting involved in the organisations, or even making a contribution to the Human Rights Network or to Refugee Action, then that's what you can do. You all can play our part in seeking to challenge what is at the core of the current strategy for setting aside at least 70 years of human rights law, which is the foundation of what was the civilized response to fascism in the past, and I'd hope would be the response now. But there's not common consensus on how to deal with that. Thank you for coming along in person today. Thank you for all those people who are still online, and we'll hope to speak to you later. Thank you very much.